Welcome friends, welcome to Simzuu. At Simzuu we believe that knowledge prospers all. Now we have started a new series, that is Concepts and Labor Laws, in which we have dealt with the concept of natural justice. In the last video though, we have seen what is the first principle of natural justice, that is audi alteram partem, in simple words, right to be heard. Today we are going to go a bit further and going to see the other aspects of natural justice, including the next principle of natural justice, that is, nobody is to be a judge in his own cause. Now friends, those of you all who have not seen the earlier videos, I would request you all to see those videos first, so that this video could be a sequel to the first one. It's in continuation. So let's begin friends. Again, to brush up your memory a little bit here and there as to what is natural justice. Natural justice, we saw it's as old as the hills, and that's why it's called as natural. Nobody knows when the metamorphosis took place and the hills came into picture. And so is natural justice. You are born with natural justice and you die with natural justice. You need not go to a school and college to understand as to what is natural justice. Now, natural justice has a bearing on many aspects, basically in employment law and more so in departmental inquiries also. Natural justice is into two maxims, which I told you in the first video. We have seen the right to be heard, which is enshrined in a maxim which is called as audi alteram partem. Today we are going to see something else, the next maxim, that is nemo debet esse judex in propria causa. These Latin maxims have their beauty of their own. In simple words, it just means that nobody can be a judge in your own cause. Suppose, I'll give you a very simple example, that suppose if I kill 20 people, police arrest me, they take me to a court of law, and then in the court of law I say, I am only going to decide my case. How would that be? The question is that if you have killed something, you have done something, you have committed a misconduct, somebody else is going to decide. And that decision making by the other person should be impartial. So the inquiry officer should, whatever he does, should smack of impartiality. He is not biased. And this is exactly in the second maxim what we are going to see, that is nemo debet esse judex in propria causa. A judicial authority is required to be impartial. They say a judge like Caesar's wife should be above suspicion. Otherwise, what you are going to get from the court is a decision and not justice. What people want is justice, and what people, some of them accuse that they are getting decisions, but what they want is justice. Now friends, the essence of the rule is, first is notice, second is opportunity to be heard, third is solemn judgment. And any act of the parliament, as we are passing through the subject, which is made against the principles of natural justice is again void. The courts of law cannot sit in judgment upon the legislature. As you are aware that the three wings of the Indian polity, the legislature which lays down the law, all our MPs and MLAs who sit in the Vidhan Sabha and in the Vidhan Parishad as well as Lok Sabha, and all of they are law making bodies. It's the legislature, they make the laws. And the laws which are made have to be implemented, executed, which is done by another body, which is the executive. The police are a part of the executive, irrigation is executive, income tax department is executive, prison department is executive. In simple words, organs of the government. Now friends, the third body, that is the judiciary, is with which we are more concerned. The judiciary interprets the law. So the legislature lays down the law, executive executes the law, and the judiciary interprets the law. And the courts of law cannot sit in judgment over what is passed by the legislature, because the legislature is the collective will or the collective wisdom of the people of India. People have voted their representatives, who in turn sit in the Parliament of India and make laws which are applicable to you and me. But who are those people? Who are those MPs? And what do they represent? They represent the collective will of the people of India. And if an act of parliament authorizes a procedure which is inconsistent with natural justice, then it is deemed to be noted that it is purposely they have ignored the application of the principle. Now friends, principles of natural justice are not protected by the Constitution. Constitution, as we all understand, is the fountainhead of all powers. The principles of natural justice are not recognized, of course, as fundamental rights. You are aware, fundamental rights are found in Part 3 of the Constitution of India. But principles of natural justice are not recognized as fundamental rights, and therefore they have no constitutional status itself. And say Article 19 are the 7 freedoms, which of course there are reasonable restrictions. Article 19(1)(a) is freedom of speech and expression. Article 19(1)(c) is right to form an association. Then you have right to movement, right to trade, profession and calling, and all of that. So the question is that all of these rights, are they unbridled rights or they have been curtailed by something? So we have Article 19 into bracket 2 to 6, which says that reasonable restrictions can be imposed, and it is open to the legislature to prescribe the rules of natural justice may be followed or may not be followed. So it's open to the legislature. Yes friends, now we have to understand that natural justice also cannot be made a touchstone to find out the validity of any piece of legislation. Legislation lives on its own, and the doctrine of natural justice is ever subservient to law itself as per the Supreme Court. So whatever is the law, that is going to always prevail over natural justice is what we have to understand. Now there have been so many famous cases, landmark cases, say for example A.K. Kraipak versus Union of India, wherein the Honorable Supreme Court put forth that the aim of natural justice, what is the aim basically? The aim is to prevent miscarriage of justice, and it is presumed that the legislature and the statutory authorities are constituted in such a way that they intend to act in accordance with the principles of natural justice. And courts also cannot ignore the mandate of the legislature. If the law states that natural justice is to be followed, the answer is final that it is to be followed. The express words of the provisions conferring the power are to be seen, that it is because of these words this power is conferred upon this statutory body or authority which is to be followed. Now friends, the statutory provisions will be construed as implying the principles of natural justice. If you see a statutory provision, the law, it is presumed that it includes natural justice. And the presumption is that the legislature requires all the quasi-judicial tribunals, say like departmental inquiries, to follow the principles of natural justice. And if a statute can be interpreted, now you see statutes, that is the laws, have to be interpreted. And if the statute is to be interpreted consistently and dehors, that is against the principles of natural justice, then it is to be read basically in consistence with the principles of natural justice. That is the rule of interpretation. And all laws of procedure, it should ever be borne in mind, are grounded on the principles of natural justice. And what happens friends, if there is a conflict between a natural right, even though not guaranteed, and unless the statute directs a tribunal to act contrary to the principles of natural justice, the presumption is that natural justice is to be followed. Sometimes the legislature frames a law that in such cases natural justice will not be followed. We saw some examples in the earlier video. In that situation, natural justice need not be followed. Now you see friends, that if a statute provides the rules of procedure, it is sufficient that those procedures are followed. Then that would be enough application and enough following of the principles of natural justice. Of course, those have to be laid down by the legislature. Now the principles of natural justice, whether they are implied in any contract, in any settlement, or even under the standing orders, I have already explained to you standing orders means the rules which are applicable. Unless there is something negativating the application, the application of natural justice is an implied term, making it very simple. So unless the statute says this will not be applicable or natural justice will not be followed, it simply means natural justice is to be followed. Suppose if a worker gives in writing that it's okay for him that there is an automatic termination of his service, it is okay that you don't follow certain things, what would be the position? When the standing orders lay down the acts and omissions as amounting to misconduct but do not provide the procedure, then we see that the natural justice is violated. Procedure has to be followed, natural justice has to be followed, the worker should be told in advance. So many of the things, in simple words, I would put it this way, that not to follow natural justice would be an exception, otherwise it's an implied term in all the laws. Now the fundamental principles and natural justice in modern times, friends, natural justice is so vague so as to be practically meaningless. In most savages, there was no such thing as justice in the modern sense. If you see, they used to push a person from the cliff, or all those crude sorts of punishments are there. And justice, basically, you will all appreciate, is a very elaborate concept. Even departmental inquiry should conform to certain standards, and they are not, whatever are the findings, they should be rested on evidence and not on the misreading of the evidence. Now we see that justice should not only be done, it's a dictum by one of the English juries that justice should not only be done, but it should appear that it is being done. And a person should have knowledge, and he should also have the opportunity to know the allegations against him. Just think for a situation, I don't know what are my allegations. Then you give me a charge sheet, I am unable to read it. Then you give it to me in a language which I don't understand. And then you expect me to put up a defense also. And then you say natural justice is followed also. A record must be placed before him for his information, comment and criticism. Now you see how deeper we are delving, and then this is following the principles of natural justice. Yes, friends, in a very famous case, that is Innis versus Wiley, wherein Lord Denman said that no proceedings can be valid till a person is called upon to answer the charges. Suppose you make 7 charges against me, you will have to at least call upon me to answer those charges, grant me a hearing, and all of those things. Quasi-judicial authorities need not follow the principles of, or need not follow the procedure of courts. Principles of natural justice have to be followed. Now the workmen should be informed clearly of the charges, and to punish a person at pleasure or on account of a certain policy is obnoxious to the principles of natural justice. Now this is held in a number of judgments. Man should not be a judge in his own cause. There is a dictum, very beautiful one, I always like it. That is what Thomas Fuller said. Thomas Fuller said that a cat cannot be of the jury at a rat's trial. A cat is interested in the rat, so if you are interested in the litigation, you are already biased. Justice also should not be done, but it should manifestly, ostensibly, on the face of it, appear to have been done. And fundamental principles of natural justice are applicable to the quasi-judicial proceedings, and the tribunal should be above bias. The departmental inquiry officer or any sort of an inquiry, he should be above bias. Otherwise, it's senseless to conduct the inquiry when you have a biased inquiry officer. And justice, as I told you, should not only be done, but should appear to be done. Now, what does this really mean? This really means that when you do, or some sort of a judgment is given, one is to see that whether there has been a manifest failure of justice. And what is manifest failure of justice? It means the judgment is given or the order is given in such a manner as it shocks the conscience of a reasonable man. No reasonable man would ever come to such a conclusion. We do not require an Albert Einstein or an Edison. What would he think of the situation? Answer is very simple. Common prudent man who is walking on the road, if whatever you say is appealing to him, if he is satisfied with whatever is your theory, then friends, natural justice is followed. So, and if he does not agree, it shocks the conscience of a reasonable man who is walking on the road then you have not followed natural justice. Now, what would be the reaction of a fair-minded person with ordinary sense and sensibility is the test? What would he think? He is just walking, he is a layman, he does not understand law. Even then, what would he feel of the defense which you have taken? If it appeals to him, your defense is right. If it does not appeal to him and shocks the conscience of this reasonable man, then you have failed. Now, requirements of the principles of natural justice are variable. They are not fixed. Principles of natural justice are applied widely in different circumstances, but there is a common thread, a common element, and a common denominator. And what is that? The only common denominator is the intent to do justice. After everything is over and justice is not done, I mean, what sort of a rigmarole have you been through? What sort of laws have you followed? And sometimes it is also said that to be impartial is inhuman. It's not human. We all have our biases. We all have our favorites. We all practice favoritism. And then you have an inquiry officer or anybody, and then you expect impartiality out of him. Is this possible? Is a question for all of us to ponder, friends. Yes.